Welcome to our podcast. Today we have a friend of the podcast, someone who's been with us before, and it's a pleasure to have him with us again. He's extremely knowledgeable of the law, and he should be. He's the prosecuting attorney for Bonneville County, Idaho. Randy, what can we say? Welcome, and it's good to have you with us.
Yeah, I love to do these podcasts. They're a lot of fun.
Today we have a topic that sometimes we hear about in different applications of the law, but needs to be explained, and that is the theory or the concept of prosecutorial discretion. Tell us a little bit. Can you define it for us and tell us how it is in fact applied?
There's a little bit of a challenge when the legislature creates the law to try to write it broadly enough so that when a situation comes along that should be prosecuted, it can fall underneath this huge umbrella of prohibited of conduct which is prohibited. Those are crimes. And if you were to take those broad definitions of what can be a crime, well, you'd sweep in a lot of conduct that nobody actually intended to fall under that category. So that's why we allow prosecutorial discretion, and that begins with that's a broad term that involves anybody acting in the name of the state who is prosecuting a crime. So that begins actually with the law enforcement officers. It doesn't have to, in other words, be a prosecutor who exercises prosecutorial discretion. It begins with that first officer who perhaps sees a traffic offense and decides to write a warning instead of writing a ticket. That's a form of prosecutorial discretion. But normally when we talk about prosecutorial discretion as it applies to us as prosecuting attorneys, it's the decision whether to charge somebody with a crime and which crime that they should be charged with.
For example, under the Obama administration, in immigration law, he enacted what we know as the DREAM Act. Basically, that is a form of prosecutorial discretion that he's asked the immigration prosecutors to interpret a certain way. Is that accurate?
Yeah. In fact, during both the Obama administration and the Biden administration, there was a broad policy of prosecutorial discretion, which even went beyond that the deferred action, which was DACA, that deferred action for children who entered the United States under certain conditions. So, and basically what that was is they said as a broad prosecutorial discretion, categorical prosecutorial discretion, then we're not going to seek to remove this particular group of individuals, child arrivals. DACA, the CA stood for childhood arrivals. But even broader than that, then prosecutors that work for immigration, for ICE, Immigration and Customs Enforcement, were instructed that priorities were going to be put on to national security threats or other things that the average person who came into the United States just to get employment would not have fallen under. And so this was that prosecutorial discretion that we're not going to push that part of the law. But in the more common use of prosecutorial discretion, every morning when we start our day here at the prosecuting attorney's office, then we have either arrests or reports that have come in to us, and then we look at what the charges were, and we either agree with those charges that were made by the law enforcement officers, or we may get a warrant request where they're saying, we're not sure how this case should be handled or what it should be charged or whether it should be charged. And then we will look at the facts and circumstances of that particular case, and then we would make a determination whether somebody should be charged, and if so, what particular crime or part of the statute we should look at.
When you reach an agreement with the defense or you offer what is known as a plea bargain, would that be considered prosecutorial discretion?
I take it back a little bit when I hear plea bargain. we make plea agreements, but we try not to be a bargain, right? Plea bargain was, a term that they used when we really started using lawyers to try to resolve criminal cases back in the 70s, as opposed to taking everything to trial. And that probably began with the war on drugs, because you went from a situation in the 50s and earlier where you may only have 16 felonies on the books and every felony went to trial, to where you had potentially hundreds of crimes. Most of them, or a majority of the new felonies, had to do with increasing penalties for and trying to control drugs and controlled substances. So when that onslaught of new charges came along, that's when we really started seeing the courts overwhelmed. Nowadays, with 1,000 felonies that we charge each year in Bonneville County, if we took every case to trial, we would have to build a courthouse 13 stories tall. And even if we could get all of the judges and courtrooms, there would be the question of bringing in all the juries every week. Running all these 1,000 trials would just overwhelm the system. Not to mention, each of those courts would cost, the total would be millions and millions of dollars to operate them. And so really what we're seeing is kind of a delegation of what normally would have been part of the jury system and our judges. And now a lot of that discretion is being worked out among the attorneys, so the prosecutor and the defense attorney. And then we come to an agreement which is beneficial to the defense attorney on their side, but beneficial to us as well, because we're handling a really large amount of cases, and we just couldn't take every single one of them to trial. So we look for a just result as best we can. And in many cases, that would have met our prosecutorial goals, or it would have probably been the same outcome even if we had gone to trial, as far as what penalty we may see. So often when we do a plea agreement, what we may do is dismiss this charge or that charge, but the main charge is probably the one that they'll plead guilty to. And then we'll make a recommendation on sentencing. And again, the two attorneys basically use their experience to figure out, what's the likely result if we just went through with the whole process, and can we get there? And everybody has to give up a little bit. There's compromise involved with that.
There's a bit of a perception that is not quite accurate that when a prosecutor agrees to a plea agreement, that it benefits the defense more than the state. How accurate is that? And what are some of the circumstances where you, for example, choose not to prosecute to the full extent, or perhaps differently than if you come to an agreement with a defense, a plea agreement?
Yeah, so in my office, what I instruct my deputies to look at is to look in kind of a complex way at where the defendant falls on the spectrum. So the question has to be, is this somebody where the underlying reason for their criminal conduct may be addiction, or it may be mental health, or it may be just because cognitively, they're not able to really do well as an adult in our community because they just don't have those skills. That makes it difficult for them to be successful, and that makes it difficult for them to make enough money to be stable. And then, that's where we start seeing potential for crimes. We have a small group of people that fall probably within a 10% or less of those folks that we see, who are just criminal thinkers. The law doesn't apply to them. They're sociopathic, basically, and they cause probably 80% of our problems. And so we don't approach everybody the same way. And what I always try to do is look at what is the prosecutorial goal in this particular case. What are we looking to, how are we looking to protect our community? So we can throw somebody who is a drug addict into jail or into prison as often as they're found with drugs. We will then get them out and continue to throw them into jail for having drugs because we haven't treated that underlying problem. So somebody with an addiction is probably going to go what they call the problem-solving courts. And that's a situation where we try to address that underlying issue of addiction, which is far different from a drug dealer. Now, a drug dealer, that's somebody who's most likely involved with criminal thinking. They don't feel the rules apply to them. They're willing to just cause, destruction in our community and victimize people because the rules don't apply to them. And so those folks, drug dealers or career criminals who burglarize, steal, commit violent acts, all of those folks are a high priority for us. So our goal to protect the society with them is much different. And if we can kind of convey that to a defense attorney, what is our prosecutorial goal, then it helps us negotiate, a resolution where the community is protected. We're not wasting, millions of dollars in lengthy court proceedings, which is also important ultimately for the victim. So the victim wants this chapter closed as quickly as possible. And so putting it off into lengthy litigation, criminal litigation is not in the interest of our victims either. So if we're looking at somebody who has damaged or taken something from a victim, then we're looking for ways to restore that victim so that they can be made whole. So we may emphasize in a case like that restitution. So those are the different aspects that we try to look at. So it's somewhat categorical, but it's also very individual to whatever case came to us.
Now, the fact that the prosecution and the defense have reached an agreement doesn't mean that the judge will automatically accept it. I believe a good example of that would be the Hunter Biden case that has been in the news.
Right.
How does a judge approach an evaluation of equitable application of justice? What is the process for the judge to evaluate the agreement?
Yeah, that's a really good question. So ultimately, we don't believe in one person being judge, jury, and executioner. And so these cases are being evaluated even at the time that the first law enforcement contact is made. And then everybody takes a look at it, and there's, the prosecutors, the defense attorneys, and then ultimately the judge, maybe even a jury in the case of a trial, are all putting eyes on this case and adding their own perspective. And in the case of judges, they're using years of experience to look at this case and say, is this a just outcome? And comparing it to similar cases or even dissimilar cases and saying, well, it wouldn't be fair to treat this case the same as, a case that we did a few years ago because the circumstances are not the same. And that's that balance of mitigation, or otherwise those factors that weigh in favor of the defendant against aggravation, which is those factors which makes the crime or the conduct more severe than somebody else who has committed that crime. In certain cases, the judge, and really this comes kind of down on the prosecutor. If they feel the prosecutor has not exercised their discretion to a degree that really held the defendant to the standard that would end up in a just result, then they can disagree to go along with the recommendation. Now, the other way, it's much easier for a judge. So if the judge says the prosecutor is being too harsh, well, he can just sentence him in a less harsh way, right? He can go against the recommendations of the state. There are very few cases, Hunter Biden his initial plea agreement, where the judge says, this makes no sense. It's much too lenient, and so the justice is not being served for whatever reason, and so that's where he rejected it. In Idaho, there's actually two different types of plea agreement. One is binding on the judge, which means the judge either has to go with the recommendations or he has to give the defendant just an opportunity to withdraw from the plea altogether. The other is non-binding, which means the parties are saying, we're going to recommend things to the judge, but the judge can use whatever discretion he wants in order to reach a just sentence. And so that's the vast majority of plea agreements. The judge has the right to say, well, the state's made a recommendation, your defense counsel's made a recommendation, but I don't think either of those is fair, and I'm going to do something else.
Do you find that when you have reached a plea agreement, that although it may be the most equitable, the fair way of applying the law to satisfy the needs of the community and not be too harsh on the defendant or unusually harsh on the defendant, do you find that the victims or the victim's advocates, people who know the victim but are not knowledgeable of the law, fail to grasp really what the plea agreement means? And if I were the victim or someone I knew was victimized, I would want the harshest possible application of the law. How does it differ, the victim on his side or her side and the defendant on his or her side from each of their perspectives?
Yeah, it's like negotiating any agreement which involves compromise. Ultimately, if one person feels like they prevailed, they won, that's not a compromise, right? That's somebody, having a victory. Most plea agreements are based on the defendant, agreeing to something more than they want to, and also the state, agreeing to reduce charges or perhaps accept something that if they'd gone to trial, they could have proven in a court. But again, generally speaking, we're not really looking at lesser sentences in those circumstances. We're usually getting the same result, even though we're not going through all of the procedures that are involved with going to a jury trial. But a victim that comes in, for them, this is the most important case of from their perspective, and they may not have the experience and the perspective that comes with seeing dozens of these cases. And so there is a danger for the officers of the court, the defense attorney, the prosecutor, the judge, to look at these cases very categorically. This is a drug addiction case, simple possession case. We've got 5 of those on the docket today. We had 10 of those last week. We'll have 10 of them next week. And so when a victim comes into it, and I'll compare it to this example. When I was in law enforcement, I would pull over a car, and that was probably one of 9 traffic stops I did in my shift. And so to me, it was one of the most routine things I ever did as a law enforcement officer. Get out of my car, go up, make contact, warn them, give them a ticket, whatever it might be. And then I walked away. But for that person, that was probably one experience they had with law enforcement in maybe 5 years. For them, it would be something they would go home and describe to their family and loved ones because it was the biggest deal of their day. Being pulled over by the police is intimidating. It can be very negative because there's a consequence. Perhaps you have to start, paying a fine, or, even if you get away with a warning, there's still just this emotional impact because you see those red and blue lights and it scares you, and then you go through all of those emotions when the police officer's talking to you. some of those cases can go really dramatically bad. The officer can end up, having to arrest or getting a struggle with the suspect. So all of these things can make it very, very impactful on the individual, even though it's routine for the police officer. And it's the same in court. I mean, we see, 1,000 felonies overall in our county. We see between 13,000 and 20,000 interactions with the courts. That's all the tickets, all the misdemeanors, all the felonies. And so for us, 13,000 interactions are just super routine. But for that victim, it's probably been, an ordeal that will take months and months to resolve. And it's very emotionally impactful for them. But we try to put everything, to treat everybody the same would be fundamentally unfair and unjust. So we have to take, pieces of information and factors from many different angles to try to get that individual level of justice. And so that's where we certainly listen to victims and what they feel is a just result. And that's not just because we're good people. It's because by statute and by the Constitution, their voice has to be heard. And we gladly welcome that input. And ultimately, though, there are forgiving victims who would be way too lenient if their perspective was put through. And there are vindictive who think they're the most victimized, person that's ever been brought into the court system. And sometimes, from our perspective, those who have probably lost the least or been affected the least seem to be the angriest and want the most punishment, where we've seen victims who have been impacted in horrendous ways who are very, very forgiving. So our job is to kind of try to equalize those impacts in some just way so that, each defendant gets treated to a just result, but also that the victim is heard and that the victim has a just result that helps restore them as much as possible.
One quick last explanation for us. How much does the technical aspect of the law play into the plea agreement? For example, as the victim, I think that this is an open and shut case. But then when you look at it, there are certain elements of the crime that cannot be applied to what the victim perhaps think would be more appropriate, but the law does not allow. What are the limitations from the technical aspect of the law that come to play when, negotiating a plea agreement?
Well, as prosecutors, we're called upon to bridge three very different worlds. So if we talk about the judge and the lawyers in the court system, they all have law school in common. They all have been past the bar and been admitted. They all have, for the most part, some level of practice in the courts of law. And so this all leads to an understanding of a system built on the rules of evidence and the admissibility of evidence. Some evidence will never be known to the fact finder. There are restrictions and limitations on what is admissible that would not apply in these other two worlds. The second world I want to refer to is the law enforcement world. Law enforcement is not held to the rules of evidence. Anybody who comes to them, they can listen to what they have to say. They can see what they see. All of those things can be considered, and it leads to a very knowledge-based approach. What do I know about this case? Where when that goes into the legal system, into the court, it's no longer knowledge-based. It's not what I know, it's what I can prove. So you're limited in that court world to admissible evidence, that is not a limitation in the law enforcement world because the rules of evidence don't apply at that stage. Their standard is probable cause. So they have to decide, did this person, to a probable cause level? In other words, it was more likely than not that this person committed this crime. That's going to be an entirely different standard when we get into courts, which is beyond a reasonable doubt based on, again, admissible evidence. Then we go to the third world, which is now officers in their world have a certain training and understanding of the law that is above and beyond what most people. But in that third world, then there may be very, very little training or understanding of the law. And really, it's not a technical evaluation of, you reference a term of art, elements of a crime. A law enforcement officer and the lawyers will know exactly what you're saying. But a person who doesn't have any legal training may not understand what an element of the crime is or what it takes to prove elements, why elements are important. Those words mean nothing to them. And that world is usually based on morality. It's based on, was what they did right or was it wrong? So we have to bridge those three groups, not only because victims come from that category that aren't looking at it in the sense, can we either prove that crime or does that conduct meet certain elements of the law? They're looking at, hey, this was wrong and I deserved a just result. Well, where does our jury come from? Our jury is not, they're restricted to what they can hear in that third world, but they are not, again, they're not trained in the law. And so that's where juries tend to really think of things as right or wrong from a moral sense, even though the lawyers will argue very strenuously about the elements of the crime or whether it met the burden of proof or whether it goes beyond a reasonable doubt, those kind of legal arguments. So that's the real challenge of a prosecutor, is trying to bridge those three worlds.
Randy, thank you so much for joining us in this podcast. I think that you've given us a different perspective as to what a plea agreement, not a bargain, a plea agreement actually is, and some of the elements associated with the thought behind what to propose and what to agree to. It's very interesting and is very informative. I think that we should do this periodically, maybe once a month. And next time, I would like to bring to you certain things that usually happen during a trial, objections, and what constitutes an objection and what are the grounds for objecting to some particular motion or some particular element of the trial. Perhaps talk about some of the most commonly misconstrued, should we call them perceived rights that people have when dealing with law enforcement or when going to trial? Would that be a topic we may want to cover?
Sure. And I think we can talk about the difference between reality, what we see in our courts of law, and then what we see in the movies or we read in the books. I'm as entertained by those as well, but you don't want to be bringing your techniques you learned from my cousin Vinny into the courtroom. And then on the other hand, to be effective, you always have to remember that a jury is affected by those conceptions about what a trial is really like. And, one thing that happens with me routinely when people find out I'm a lawyer or a prosecutor, then they'll talk to me differently. They'll start throwing out terms that they've heard, and it's always fun to see somebody trying to learn more about the world that we deal with, that third world of objections and rules of evidence and admissibility and those kind of things. But, I would encourage people to stay away from that. I'd love to be in the real world where I don't know, I bake cookies or do something a little less confrontational and a little bit that just cheers people up.
Perfect. We'll talk about those subjects and the irrational thought of doing anything pro se. And we'll leave it at that.
All right.
How's that?
Sounds great. I look forward to it.
Well, thank you. Randy Neal, prosecuting attorney for Bonneville County in the state of Idaho. Thanks again, Randy, and thank you for joining us on our podcast.
Thanks, George.